Now in the last video we talked about Ex parte McCardle. And in Ex parte McCardle, the Supreme Court told Congress, hey, you can take away our appellate jurisdiction to hear a case or a class of cases. Don't you love this? I'll be back in a minute. Okay, that issue was resolved. So, the Supreme Court told Congress you can take away our appellate jurisdiction in a case or class of cases at any time before we issue an opinion and a judgment in the case. The Constitution says you can take away our appellate jurisdiction, so you can take away our appellate jurisdiction. What happened in Klein? Klein involved the issue of presidential pardons, and you have to be aware that there's a Supreme Court case that comes before Klein that sets this up. In a case before the Klein case was litigated, the Supreme Court had already held. So listen to that. Think about that for a minute. What had the court said in McCardle? You can take away our jurisdiction to hear a certain type of case if we haven't already decided the case. What I'm telling you here is that there was a case before Klein where the Supreme Court had already made a decision. And the decision that the court made was that the effect of a presidential pardon was to establish innocence. So what's going on here? We're post-Civil War. The rules are, because a lot of property had been confiscated in the course of the Civil War, particularly obviously in the South, that if your property had been seized during the Civil War, you could get it back if you could show loyalty to the Union, that you were loyal to the Union. If you could not show that, then you're not getting your property back. Your property has been forfeited. Those are, again, part of the rules under the Reconstruction laws. Now, people were coming into federal courts claiming that they wanted their property back and saying that they were entitled to it back because they could demonstrate that they were loyal to the Union. And to establish their loyalty to the Union, what they were proffering, right, that's a big word in the law, what they were proffering as proof, as evidence, was a presidential pardon. After Abraham Lincoln's assassination, Andrew Johnson ascended to the presidency. He was known to be a sympathizer, by the way, to Southern interests. And he was handing out presidential pardons like candy. The Supreme Court ruled that a presidential pardon is conclusive proof because the effect of a presidential pardon is to erase guilt, to erase any of the underlying facts that would have established guilt. Therefore, the Supreme Court says a presidential pardon is conclusive proof of loyalty to the Union and does entitle somebody to get their property back if it has been seized in the course of the Civil War. Well, Congress gets wind of this, obviously, and Congress is incensed. They are extremely angry about it. They disagree strongly with the notion that presidential pardon, which as far as members of Congress are concerned, are mostly a matter of political favors and not a matter of actually evaluating the facts of a case. So they're not buying this idea that a presidential pardon erases guilt and establishes loyalty to the Union. What do then? In response to, listen to what I'm saying, in response to a decision that has already been made by the Supreme Court, they then, a judgment has issued, an order has issued, then after the Supreme Court has already decided the issue. So Congress didn't bother to stop the Supreme Court from deciding it to begin with. After the Supreme Court had already decided it, then Congress decides we're mad about that and we are going to remove the jurisdiction of all federal courts to entertain cases where presidential pardon is proffered as evidence of loyalty to the Union. Two principles emerge from the Klein case, and we will review this in our live session, but I want to get this on the table. Number one, and what happened here? Congress has a new toy. So they think we have this new toy here we can play with. Anytime we disagree with the courts or anytime the courts make us mad, take away their jurisdiction. So now it's time for the Supreme Court to clarify that its ruling in Ex parte McCardle was not licensed for Congress to abuse its jurisdiction stripping power. So here are the two principles that emerge from the Klein case, where the court is not too happy about what Congress has done. Number one is a temporal, time-related issue. You may use your jurisdiction stripping power, Congress, you may use your jurisdiction stripping power to stop us from deciding an issue to begin with. In other words, your use of your jurisdiction stripping power should be forward-looking. You should only be using your jurisdiction stripping power to stop a federal court from making a decision that you don't want a court addressing. It should not be backward-looking, where you are taking away federal court jurisdiction not to stop courts from making a decision you don't want them to address, but to punish courts, essentially, for making a decision already that you disagree with. I'll repeat that. The first principle to emerge from Klein is Congress, when you use your jurisdiction stripping power, what that means, what it even means, is the power of Congress to stop federal courts from hearing certain kinds of cases before courts decide those cases, not after. I hope that makes sense. Apply that to these facts. In McCardle, you stopped us from issuing a decision that you didn't want us to reach, and we said that's fine. In this case, in Klein, what you've done is you waited until we already made a decision on what is the effect of a presidential pardon, and then, after that decision had been made, then you exercised your jurisdiction stripping power with regard to that class of cases, and at that point it is too late. That is an interference with judicial power by the legislative branch and is, again, a violation of separation of powers principles. So the first thing you want to look at, when you see Congress taking away the jurisdiction of federal courts, or the appellate jurisdiction of the Supreme Court, when Congress is messing around with the jurisdiction of federal courts, taking away their jurisdiction, that's called jurisdiction stripping. When they're doing that, look at the timeline and ask yourself, is Congress doing this to stop courts from hearing cases, or is Congress doing this because it is mad? That's what I'm talking about. Or is Congress doing this because it's mad about a decision that has already been made? If they're trying to stop courts, that's okay. If they're mad about a decision that's already been made and they're using their jurisdiction stripping power to address that, that's no good. The second principle to emerge from Klein. The court says the essence of what's going on here is that we made a legal determination that Congress disagrees with. Under our system of government, Articles 1, 2, and 3 in particular, it is up to the legislative branch to make law, it's up to the executive branch to execute the law, and it's up to the federal courts to interpret the law. See where this is going. We've been talking about this for a while in a couple of these videos. So, Congress is upset about how we interpreted the law. They're upset about the decision that we made. They're upset about the way we weighed evidence. They're upset about the way we deliberated. They're upset about obviously the legal conclusion that we reached. That, frankly, here's what the court's saying, that is none of Congress's business. So, principle 1, jurisdiction stripping should be forward-looking, not backward-looking. Principle 2, Congress does not get to tell courts how to decide cases. You can tell us not to decide cases, but you can't tell us how to decide cases. If we think either that you are targeting a past decision, you're exercising your jurisdiction stripping power to target a past decision, or if we think that the reason you are using your jurisdiction stripping power is that you disagree on the merits with how we evaluated a case, either one of those is grounds for invalidating a jurisdiction stripping law as a violation of separation of powers. So one more time. Number 1, you can stop us from, in the future, hearing a certain kind of case. You can't use your jurisdiction stripping power after we've already decided it. Number 2, you can tell us not to decide cases, but it's not your business how we decide cases. If we see a violation in either one of those areas, we're going to say that the jurisdiction stripping law passed by Congress is invalid. So, does Congress have the authority to regulate jurisdiction of federal courts? Yes, to a certain extent. They're not allowed to mess around with the original jurisdiction of the Supreme Court. They may regulate the appellate jurisdiction of the Supreme Court as long as they do so before a judgment issues. If they're messing around with federal court jurisdiction, Congress, because of a decision that's already been made, that would be an invalid violation of separation of powers principles. And furthermore, if they're using their jurisdiction stripping power because they don't like the way federal courts have deliberated, they don't like the way courts have decided a case, that is an invalid violation of separation of powers, because it is Congress's job to make law through statutes. It is not Congress's job to interpret the law. And if Congress disagrees with a judicial interpretation of the law, that's just too bad, because that's none of Congress's business. Stay in your lane. All comes back to that. Okay, so that's enough on Klein. We'll come back with more about Supreme Court jurisdiction in the next video, but we've got a good start here, hopefully, on McArdle and Klein. We will again talk more about this during our live session, but I want to get these principles on the table so we can talk about them intelligently and you can generate any discussion or questions that you might have. Stay safe and stay tuned.